Mickey talks the truth.
Okay. I got truth on my mind. Truth on my mind. I got truth on my mind. Truth on my mind. I got truth on my mind. Truth on my mind.
Hey, listen, you are now rocking with Mickey Truth. She live up to her name, not the fame. So make sure y'all subscribe to her channel and stay updated on what's real. Bye.
Good reporting ass Mickey.
We love you, Mickey.
Y'all already know all information contained on this live is for entertainment, heavy on the mother effing entertainment, educational purposes only. All information used on this live is per the Fair Use Act, and any conclusion that you draw is on you and your mama. Not nobody on this channel, this panel, or in this chat. And another disclaimer for those who have not read the description to my channel, I am not a lawyer. Nothing I say should be used as legal advice because it's not legal advice, okay? If you do need legal advice, however, you can go talk to an actual licensed lawyer or attorney of your choosing, all right? And like the disclaimer says in the video, that you can actually see the consequences of anything that you try to run with from the channel is definitely on you, all right? So with that being said, hey, just sit back, enjoy my opinion based off my free thoughts of what I'm listening to, and y'all let me know what y'all think in the chat. Let's get started.
You can't handle the truth.
Make sure you like, comment, share, subscribe, tell a friend to pull up on your girl Mickey Truth. We is live with it. Good morning, Truth Team. Welcome to another live, y'all. I'm in the process of finally taking my braids out. So, yes, I'm going to be taking my braids out during this time. I need everybody to hit the like button. Good morning, Karen, Bart, Cody. Good morning. Thank y'all for pulling up. Y'all already know how it goes on the live. We are watching day 2 of YNW Bortlen's hearing, okay? This is a motion hearing. They have multiple motions, including motion to basically throw out his statement that he made the night of the murders. They have a motion to basically stop the trial from beginning next week, and a couple other ones. Tyroid, good morning. It's a few of them that they had going on, and we're here. Yesterday, if y'all wasn't on a live with me or didn't check out our conversation, they did offer YNW Bortlen a plea deal. Yes, 16 years. And you may be like, well, 16 years? Good morning, Nikki. Yes, 16 years. And that means they was taken off the 2 bodies, the 2 murders. Y'all may be like, why would they do that? Because they never felt like he actually had nothing to do with the actual shooting. Their theory when it comes to Bortlen is that Bortlen participated in knowing who the shooter was, helping the shooter cover it up, and trying to sway the police afterwards, as we heard so far. Okay. Shout out to everybody that has been in the comments. A few of y'all need a review. Y'all telling me to review. Y'all need to review the case and the Melly's first trial. Now, let me say this. This is not about, I'll be scouting. I'm gonna cut my hair. This is not about Melly, okay? At the end of the day, just like they never had to call Bortlen for Melly, they don't need Bortlen for Melly. Okay? They don't need it. A lot of y'all done jumped to, oh, he about to snitch. He's snitching. Y'all, like I said in my video, for those who paid attention, I said, hey, it's a no contest plea. Just like, well, hell, I hate to mention his name right now, but just like Young Thug, keep playing no contest. Meaning, I ain't saying I didn't do it, but I'm gonna agree to the terms of this. Okay, now you can take that as, hey, you saying that because guess what, you did it, or you can take that as what it is. It's a person saying they, didn't or did do it. They ain't saying nothing. Where we at? Good morning, Alex. Pussycat is crazy. Good morning, Julian. All right, so I'm sorry, I was cutting the ends of my braids. We have a few moments before the feed starts. I'm going to get into let's clear up this. Somebody, and I kind of went back and forth for a little while with them in the comments, but somebody said, because on the live I was speaking to somebody in regards to Melly participation about cell phones and getting out of the car, and I said we don't know when Melly got out of the car, and I say that in comparison to Bortlen. We don't have a video of Melly getting out of the car. They have the phone for Melly, or who appears to be Melly. And again, I done windmill with y'all about that multiple times during Melly's trial. At the end of the day, anybody can have a phone. We don't know who had the phone, okay? So that was that. But Bortlen did not have a cell phone. I'm saying it again, because boy, they was trying to come at me in the comments about that. Bortlen did not have a cell phone that night. When they said that two phones separated from each other, they referred to YNW Melly's phone and the victim phone. And I believe it was Sat Chaser's phone, because remember, Juvie phone was pinging somewhere else. Okay, so that's the phone. They don't have a phone for Bortlen. What they have for Bortlen is, guess what? Video of him getting in the car, video of him getting out the car when it was two deceased people in the car. Okay, that's what they have. Let me see. As far as the plea deal, it doesn't even sound like he has to testify against Melly. Yeah, a lot of y'all was jumping to that. Y'all know you mentioned a plea. Oh, you got to tell. And you know, at this point, when it comes to content, it gets y'all to talking. But come on, be realistic, y'all. Just because you hear a plea deal do not mean telling. Okay? If somebody can tell y'all they did a proffer and y'all don't think that's telling, then I don't know why y'all be jumping to conclusions with plea deals. Okay, it's a no contest plea, like I said, in my opinion, based off my experience, okay, professionally and personally, dealing and looking at these cases. Listen, if you're not telling them what you did, okay, your plea don't include you having to tell what you did. Why the hell would you have to tell what somebody else did? That's just how I look at it, you know. Hey, y'all can take it like I want. Good morning, Paradise. Good morning, making my prayers go out to your family. I appreciate it. For those who are not aware by now, my cousin is still missing. This is day 7. Okay. I posted a video this morning. Her youngest daughter has spoken out. Her niece has spoken out. Both my little cousins. They took to their social media to speak, and I shared it in my last video. It'll be more to share as they continue to, talk about it. I'll be sure to bring it. They're trying to grow the awareness on TikTok. Y'all know my audience is YouTube. So I'm sharing what they're sharing to their TikToks and things to YouTube. Okay. Again, any information, please reach out to somebody in the family, reach out to Crime Stoppers, reach out to the police. It's City of Columbia Police Department, Special Victims Unit. The boyfriend is still in police custody. The feds have a hold on him, so he won't be going nowhere. But he isn't talking. And we're just looking. Like I said, this is day 7. We're just out looking. I'm gonna be out again, just like yesterday. I leave about 11 o'clock to go searching, and that's gonna be the same for today. However, if the hearing is still taking place, I'll be in the comments. Okay. So I do appreciate everybody, and I'm gonna bring y'all as much information as possible when it comes out. The police obviously don't tell us too much because they don't want too much to be put out. So I feel like my little cousin did a good job with giving the backstory in her TikTok video. Because she went multiple days before the disappearance. She did a great job breaking down the backstory up to where we're at currently. As I even told y'all myself on my video yesterday, at this point, the only question we need answer right now today is, where is she? Where is she? We don't know. We're looking. So that's the most important question right now. Of course, once we get that out of the way, other questions will definitely, come about. But that right now, we just need to find her. Okay? Definitely find her. But I appreciate y'all for that. We should be starting momentarily. It's that Bortlen really take it, in my opinion. Going to trial is risky. 16 years is awesome compared to 5 life sentences when you have 1 life. That's true. I will say this. Y'all know I be telling y'all take it to trial. I be like, in my opinion, if you ain't giving me freedom or less than double digits, then I'm taking it there. The reason why I said, and this is just from my opinion, that Bortlen should take the deal is because, to me, if I was on the jury, I would convict Bortlen. I know a lot of y'all was in the comments yesterday saying they don't have no evidence. That's why they offered him a plea. That's not necessarily how that works, but I get y'all concept. At the end of the day, if I was on the jury, I would convict Bortlen at this point. And this is based off the evidence that's currently in. Of course, when trial actually start, if it goes to trial, maybe he has a great attorney that can put holes in it, and I may change my mind. But right now, if the jury had to go in, I was on that, I would definitely say guilty of all charges as charged. And y'all may be like, Mickey, why would you do that? They don't have no evidence. They got a video of Bortlen getting his tail in our car with the victims. Okay. They have a video of Bortlen getting out that car with deceased victims. Okay. They have a statement of Bortlen putting himself there. They have a statement of him saying what allegedly happened. Then when you put the evidence of the experts on there, how he had to be in the car, how it was a stage drive-by after, how the bodies was shot after they was deceased. Again, I would convict him. Like, on some real stuff, I would convict him. So if this was one of my relatives, I would have told them, if I was on your jury, I would definitely find you guilty. You need to accept this plea. Now, again, if his lawyers, and then I see a lot of the blogs, as always, didn't have, because y'all got to remember and listen, a lot of these blogs, they have people that be in and out of stuff. So they don't really be watching for real. Because they say he had until today. No, he has until Monday to make his decision. Okay? They have until Monday. Orange Crush said if he shuts his mouth, he goes home. Negative. He's not going home. This is my opinion. He's not going home. He's not going home on the plea deal. He ain't going home on the trial. Unless his attorneys win with throwing these motions out, throwing this evidence out, he will be convicted. Julius, I thought he had until Tuesday. Hold on, Tuesday the 9th though, right? I thought he said Monday. Okay, might be Tuesday then. All right, here we go. We're about to start.
First U.S. President, on behalf of the state, today is set for a continuation of the evidentiary hearing on the renewed motion to set bond, the Arthur hearing, which I heard on August 8th, 2025, as well as August 15th, 2025. And likewise, today was the day that I put on the return on the order to show cause for witness Erica Lugo to appear in this courtroom in front of me at 8:45 a.m. Mr. Percio, I did read everything in the court file. I saw all the pleadings that have been filed. Is Ms. Lugo here this morning?
I have spoken to her. She said.
Let's put your hand up. Oh. All right. So that being the case, it will probably be my intention to continue the hearing at this point. Mr. Gibson, you got the witness present now. You can call the witness, ask whatever questions you want.
Thank you, Your Honor.
Would you like the client to sit over there with you? Okay. Mr. Baker, you can go there and sit with your lawyer.
Now, who is that? That's not him, is it? No, that's somebody else.
All All right, so let me dispatch with the rule of show cause first, and then we're going to resume the hearing. Ms. Lugo, can you step up here real quick? Good morning. You're Erica Lugo.
Okay, we're gonna watch it, y'all.
That you did appear. So at the end of the proceedings this morning, I'm just going to dismiss all this. That's going to be done. But just so you understand, because I read all the pleadings that you filed, all the rules apply the same, whether it's a civilian, whether it's a law enforcement officer, whether it's the state that subpoenas you, whether it's the defense that subpoenas you, anyone. If you get a subpoena, you got to come to court and answer the subpoena, all right? If the lawyers want to ask you 100 questions and your answer to all 100 questions is, I don't know anything about that, you still got to come and do it, all right? So the rules apply to everyone. The last thing in the world that I want to do is put witnesses in jail. I just want witnesses to appear. That's the defendant's constitutional right to put whatever evidence he wants in front of me or in front of a jury. It's also the state's right to put whatever evidence they want to put in front of me or in front of a jury. So any questions for me about that? Okay. So, Mr. Gibson, you want to call Ms. Hugo as a witness? Yes, sir. All right, so Ms. Hugo, you can have a seat in the witness stand right there. So once you're seated, I'll get you to scoot that chair forward as far as it'll go. You can adjust that microphone so it's pointed directly at your mouth. Raise your right hand for me. Swear to tell the truth, whole truth, nothing but the truth.
I swear to tell the truth and nothing but the truth.
Okay, you can put your hand down. Can you please state your full name and spell your full name?
Erica Lugo, ERICA. Lugo, LUGO.
Mr. Gibson, you may inquire.
Thank you, Judge. Good morning, ma'am.
Good morning.
Do you know Andre, or did you know Andre McFadden?
Yes.
Did you tell this on the court? If you recall, the first time you ever met him?
Back in like 2012.
Fair to say that you knew him from what was there?
Yes.
You ever met this man there to my left?
Never.
Have you ever seen him before?
Never.
And have you ever rented a car that was to be used by him in New Jersey?
Never.
Did you make a police report that a vehicle that you had rented for Andre McFadden had stolen?
No. I plead the fifth.
You have a problem.
I never rented a vehicle for Andre McFadden. I rented a vehicle for myself.
Did I mishear, or I'm in a bit of a quandary?
No, hold on, man. You ask your question. The lawyer asks the question. The witness answers the question.
Can you repeat?
Go ahead, sir. Ask.
It was getting interesting. Why they cut it off? I was actually getting into it just now. All right, well, since I don't know who it was. It was a random hearing. Ooh. That hurt. All right, we can get back to it. So that was, I was watching it, but I feel like for them to be offering 10 years essentially with time served and 85 cents Florida, the case can't be solid. 5 life sentence versus 10 years is crazy. Now it's 16 years. I don't know what the 10 years come back. And they already said that the time only is when he's in jail. So all that time he was out on bond ain't gonna count. So at the end of the day, they offer him 16 years and some change. But listen, y'all keep thinking that this case ain't solid against Bortlen. How do you explain? Listen to the storyline, y'all. If we see him get in the car with the victims, we see him get out the car and the victims are deceased. Regular people, y'all really expect me to think that they gonna think he ain't had nothing to do with it? Plus, he put himself there if that statement comes in. Y'all got to be crazy. Y'all got to be crazy. Forget talking about the time. Just think about it. Y'all want me to think or believe that y'all really think the case against YNW Bortlen, aka Cortlen Henry, ain't strong enough for regular people to not convict his ass? Shit. Excuse my language, y'all know. right now I ain't really even paying attention, not to curse, but y'all get what I'm saying. Ain't no way. And y'all know I'm normally pro defense, and y'all know this year I have really been unbiased. Okay, I done been on the prosecution side in the case, all that. Okay, but y'all can't tell me that y'all think Bortlen about to walk out of a courtroom and not get convicted. Crazy. Bort did 3 years in jail. He was on bond for 3 years as well in total. So if he did 3 years in jail, I mean 3 from 16 is still not 10. It's still not 10. What's the pro? What's the pros of it? He's getting the murder again. He's getting the murder charges dropped. Okay. I don't even think he has to plead guilty to anything. He's pleading no contest. And although he got a no contest, and although he still has to do time, child, hey, I just, in this situation with Bortlen, unless his attorneys get a lot of that stuff thrown out, he's going to get found guilty. Mark my words. If all the evidence stays in, and nothing gets thrown out, he will be found guilty if he goes to trial. Why will they offer a plea if it's 100% certain? Y'all be thinking that every time a plea is offered, it's based off of the evidence. Sometimes it's money. At the end of the day, they want Melly. Point blank period. Okay? They would prefer to spend their time and energy getting Melly convicted. So if we can go here, we already don't feel like he actually did the murders or whatever. If we can go ahead and get him out the way with a plea real quick to save us money, we're going to do that. So y'all got to remember, it becomes political and politics plays a part. It has nothing to do, okay, nothing to do with the evidence in this situation. They got Bortlen. They know that. I'm telling they know that. That's why he only got that one offer. Like, they know that. So, normally I'll be with y'all, but at the end of the day, that man gonna get fried in the courtroom. Unless and I'm talking about his lawyer better be a bulldog. Okay? Because as it stands, I will convict his ass. Like, for real. Like, it's no way, because at the end of the day, you're going to have regular people up there like, okay, so you was in the car. You know who did it. Why would you lie? Who are you covering for? That's why they always wanted Melly to go first. Because if you convict the shooter, then you can tie in the story like, hey, he ain't do it, but that's his best friend. He covered for it. You know what I'm saying? Malik said, Mickey, why you think the state was doing everything in their power to delay Bortlen trial? And they still want a delay. They still want a delay. Because at the end of the day, if Melly get found guilty, Bortlen's definitely going to plead out. So to them, and this is my opinion, because I don't work for them. I don't know what they got going on. To them, it's still going to save no money in the end. But hey, y'all, most of y'all, not all y'all, because some of y'all just coming from the Melly sector. But those who was here for the Queso trial, y'all thought Queso ass was going to walk, and I told you he wasn't. Okay. Blacklight said, I thought he rejected the deal. We don't know if he rejected it or not. He was offered it, but he still, got time. They want Melly first. Yeah, because Melly, y'all got to understand, it's a money thing. Melly is the shooter to them. Melly did it. That's who we need to focus our resources is. Why are we wasting resources trying to go to trial with somebody we know who ain't do it? Just help cover it up. So, again, like I said, y'all might be right. But if that was my people, nah, we ain't about to risk that. Because at the end of the day, you can't say they don't have nothing on them. Like, he's with them. He's literally one of the last people that seen them alive, and he arrived with them deceased. Come on. Like, really think logically. Like, for real. Queso had 2 people get on the stand and testify against him. And you got videos of Bortlen. You can't compare. What y'all talking about? What you mean you can't compare? It's evidence. Like, forget actual physical witnesses. It's the evidence. You got video putting Bortlen with the victims alive and deceased. What we missing? Like, what we missing? Unless I'm tripping, maybe because everything I got going on, maybe I'm tripping. Because I just don't understand how y'all really think they ain't got nothing on Bortlen. This ain't a Melly debate. I definitely have different feelings as far as they evidence against Melly. But come on, you got Bortlen himself saying he was there. Somebody explain to me, well, how he's going to get himself out of saying he was there if they keep it in there. Like, for real. Said they should give Bortlen time served to testify against Melly. He's not going to testify against Melly. If that's the case, he would have got this shit over years ago. So I definitely don't think he's going to give up Melly. If it's something to give Melly up on, he's not going to do it. Orange Curse said, real weird feeling. It's been like 9 years. Hey, maybe. Like I said, this is just my opinion. Just like a lot of y'all, I've been covering this for years at this point. Bortlen always was cooked. If Melly would have got found not guilty, his defense could have said it was random people. They even got it wrong with who they thought did it. You know what I'm saying? Like, at the end of the day, Bortlen was never, like, the issue. But that's just how I feel, you know? Bortlen gonna stand 10 toes down and do life? Hell, we'll find out. I mean, why you acting surprised? The man ain't told on his friend yet. If Melly did it, Bortlen ain't said nothing. Bortlen's sitting in jail right now over this. Come on, stop it. Why y'all acting confused? Stop it. Mickey Bort got bond twice. It's a different levels to this shit. He in a way better position than somebody like Queso Melly. Malik, I don't know what you're talking about either at this point. Cause what you talking about? A better position to do what? Like, what better position is he in? The same way now Melly is in a better position because more so of people thought process. And this is what it's gonna be now for Bortlen. But you literally got him on the video. I'm waiting for somebody to explain. Good morning, Big D. Somebody explain to me, how do you explain being the last person with 2 people while they alive and the one that bring them dead? Somebody explain that to me. All y'all saying that Bortlen is in a great position. How do you explain to me how the jury is supposed to understand that? You're the last one we see on video with 2 people alive, and you're the person that bring them to the hospital, but you don't know. They done already uncovered during their investigation that, you know what I'm saying, you lied. Come on. Thank you, Betty. I appreciate it. I appreciate it. Nah, Bortlen cook either way, but he ain't want to be a rat. And taking a plea won't be red. Because at the end of the day, they don't need Bortlen for Melly. They got Bortlen's statement. They don't need Bortlen. And only thing that Bortlen's statement hindered is that he lied. Melly never lied. He lied. Good morning, young Chronic. Yeah, it's just like, I'm look, if y'all got a better stance to break down to me how you explained it, maybe y'all can win me over. But right now, y'all bugging. And I wanted to reply to all y'all under my last video and say y'all bugging, y'all tweaking. How they ain't got no evidence? I'm talking about all the criminals came out. Oh, I'm a convicted convict. I know, like, brother, and we see why you convicted convict. What you mean? They ain't got no evidence. It's not like it was in a Melly case where they're following a phone. You know, everything was phone. You can debate about a phone. We literally see Bortlen leave and arrive with the people. Come on. Like, come on now. Mickey, these people just want to argue. It's open and shut case. Definitely. And y'all know I'm always up for the debate. I'm always up for the debate, but we got to stand on business, man. We got to, y'all ain't about to spin me like y'all was doing on the last case. Y'all got to stand on it. Y'all ain't about to do like y'all did on the Goldman case. Y'all got to tell me, talk to me. I done sat here and broke down why I feel the way I feel. Y'all ain't about to do, just wait, just see. Nah, y'all break this down. Hold on, I was trying to get a comment. I think Bortlen going to take the plea deal. Melly know that he killed his best friends. Ain't nobody dumb. But in the court of law, be like, I'm gonna be honest, it's up in the air to me as far as if they proved it or not. It's not a fair case, so he better take it. I don't see Melly getting a death penalty. Nah, I don't see Melly getting a death penalty either. Melly evidence is overwhelming in my opinion. I watched the first trial, I thought he did 100%. The jury didn't. I didn't either. Hopefully they put the story together better. They ain't put the story together right the first time. Gets in the vehicle and drives off with both being alive. Arrives at the hospital with 2 dead bodies and lies, but people think he will be found not guilty. Right. like y'all talking about the evidence. Listen, the only people I need to see saying that Bortlen is gonna get off is people that think that Melly is like gonna get completely off. Because at the end of the day, if you think, no, I take it back, I said that wrong. If you think they got enough evidence on Melly, then you for sure should think they got enough evidence on Bortlen. I think I said it right this time. Y'all excuse me, I'm a little all over the place. Trying to stay focused on the content while, and y'all know I'm tender-headed, my hair is, these braids itching. Where I'm at. I think Melly going to be honest with his attorney Drew that while he might not take a plea, they're not gonna offer Melly a plea. That would be career suicide for the state attorney to take a plea with Melly at this point. This is a death penalty case for Melly, not Bortlen, for Melly. They're not gonna offer Melly anything. That's career suicide. Unless they state attorney they DA don't want to be reelected. Yeah, this is a death penalty case. You don't do all that for a death penalty case just to offer him a plea. It's not gonna happen. A case that's taking this long. I think when Melly retrial, you needed 10 out of 12 juries to say yes. You only need 8 now with the new law. He had 9. That's for the death penalty, not for the actual. That doesn't count for the trial, though. Somebody correct me if I'm wrong. That change was for, because you have to go, if he got convicted of capital murder, then they will have to do a vote on a death penalty. So yeah, that didn't change as far as a regular trial, though. Bortlen going to be the most hated by all parties. I don't think so. I do think Melly is guilty, but his case is beatable with his new attorney. If he kept the old ones, he was fried. I just think, to be honest, I'm going to be like, on both sides, that's why I said they had to get Bradley out of there. They had to get Bradley out of there because she didn't present the case right. That's why, regardless of what you think about the one person that wanted to vote not guilty, they were not convicting him on capital murder. He was getting manslaughter. So that means both sides didn't do their A1. Good morning, GTA. I'm feeling okay. I've been up, doing some things, doing content, editing content for my cousin being missing. But other than that, doing better today, trying to take these doggone braids out my hair. Where are we? The case has been botched from the beginning. The former detective messed up trying to charge Melly. Yeah, for sure. But again, Bortlen, yeah, Bortlen screwed. Especially if he go first. Like I said, his offense may have better ammo, if Melly went first and got like found not guilty, but this side is real tangled. But yeah, Bortlen ass is screwed. And for those who were saying, well, the girlfriend wasn't really a witness. Technically she was. Remember, the judge ruled in favor of the prosecution on that. So you can't say, well, she wasn't a witness or whatever. Shit. Until the judge ruled otherwise, she was. All those prosecutors need to be replaced. Well, the lead prosecutor is different. If you watch the trial, you know he's guilty. Cap. Obviously. Because the people that was there to do it was only going to find him guilty of manslaughter. And you got to watch back what the manslaughter included. So, yeah, we can agree to disagree on that. But they still ain't convinced me of nothing. On the Melly side, the first go around, like they had me in the middle. If I was on the jury, I would have to vote. Either I couldn't come to a decision or not guilty, because at the end of the day, it was okay, I see him getting fired, okay. And then what happened? But the defense did do okay for me not to want to convict him of capital murder. And then at this point, hell, if he did get convicted of manslaughter, he'll be about done with his time. Melly need to use that gang stuff to his advantage somehow. I don't see how that would help him. Especially since he's not even saying he was there. I feel like the prosecution and the Melly side of it, they focus too much on gangs. Too much. They gamed me out in that one. Too much. And I think it lost the jurors. If Bortlen take the plea, Melly is getting life. Bortlen plea has nothing to do with Melly. Nothing to do with Melly. So y'all stop adding those together. It has nothing to do with the other. I like Melly's lawyer, attorney for the last trial. He sucked. The black guy sucked. He should let him go. He should have let him go. He don't need Brian Steele either. Brian Steele wouldn't be the right lawyer to me for him. I feel like he got Drew feeling, right? That's his name, right? Drew feeling. Y'all, they finishing up a hearing for somebody else, and then the Bortlen one will start. So y'all know we just hanging out. But I need for y'all to hit the like button, because it's 210 of y'all in here, only 36 likes. Come on, let's get it together. Y'all see I'm in here trying to multitask to bring y'all the content, take my hair out and everything. So I need y'all to hit that like button. I thought he was good, but you are probably right. There's a reason he let him go. Yeah. He definitely needed Drew Friendland, or whatever his name is, the $1 billion lawyer. And the reason why I say that, because his clientele has been definitely those facing bodies. I know a lot of y'all be like, oh, he just do pleas or whatever. I mean, regardless, he's used to dealing with murderers or accused murderers. At the end of the day, you know, Brian Steele is more, if you ask me, is more the drug kingpins, you know what I'm saying, the gang members or whatever. But, you know, not a lot of the cases I follow with Brian Steele of urban content are actually murderers. Now, I could be wrong. I'm just going off a little bit I looked at. Drew Finland, again, you know, Wife and Lucci, that had a murder on it. You know what I'm saying? Young boy had all the gun charges, drug charges. We all know he done dealt with alleged gang members before. So, ooh, Lord, y'all. I'm so tin-headed. It hurts so bad. Mickey, I know this is off topic. Is there an update on the autopsy for the young lady who's unalive by her husband in Jordan? No, they denied my request again. Say it was still an open investigation. Drew is definitely a good plea out lawyer. And I'm gonna be honest, for Melly, if Drew can work out a plea, which I doubt because it's a death penalty case. But if for some reason, because hell, he make the money to do stuff like this. If for some reason, if he could get him a deal for like manslaughter or something, time served or a little more time less, I would take it if I was Melly at this point. Cause boy, they ain't gonna never let you free. That's another motion that they're doing too for Bortlen is bond. So they're doing an author here also. Just FYI. Standing 10 toes down was sold the 80s. It's 2025. We telling people who won't even involve. We telling on people who won't even involve in the case. We ain't told on nobody. Y'all better stop saying we all the time. And hell, at this point, shit, we don't know if Bortlen told on nobody. Hell, he ain't even told on himself. I don't want to miss the start of the hearing because I want to replay that. Because was y'all listening to the judge? No contest, meaning he ain't even telling on himself. So who is he telling on? Y'all be so quick to be ready, and then half the time it be the same stuff. Y'all don't even be understanding for real. That's why the snitching stuff just be outrageous, because y'all just be so quick to call saying somebody snitching or whatever and don't even really know what snitching is in a court of law. That's why I hate when a lot of like the street nigga bloggers get to talking about court cases and snitching. Like, bro, just say according to what your thought process on the street level is snitching. Stop saying, oh, the case said the paperwork. Paperwork ain't say nothing you saying. You saying that shit. That shit be so aggravating hearing people do that. Like, that's crazy. Bortlen better take the interrupt trial. Lamar, I'm gonna have to disagree with you on that one. His ass gonna get fried at trial unless this motion hearing with some of this evidence goes out. Because remember, all the evidence that got tossed in a Melly case is still in on Bortlen's side. Remember that too. For those who keep saying they ain't got no evidence, standing 10 toes down is so played out. Telling on people is a new hip thing. Okay, salute to you for that. Thank you. Quick to put that snitch on somebody. Okay, anybody, everybody. Hell, even like it just the shit just be. Let me stop. Y'all know I be said some shit just now. Okay. If he go to trial, basically Melly basically coming out, that don't mean that at all. I'm not gonna lie. That boy needs to take the plea today. I don't give them time to take it back. You'll have a release date. Like I said, what's up, hip hop news? If they're offering a 16, they're not 200% confident that they can get a guilty verdict. Cap. I'm gonna say cap, Lamar. That is not what that means. This is a money thing here. Why waste money trying this nigga? We gotta try the shooter again. Like, we gotta try the shooter again. Lamar, you know how politics work with this? This here ain't evidence situation. This here is money. They dropped the ball. The important piece of the pie is freaking Melly. And they dropped the ball the first time, got this running back again. They fighting Supreme Court appeals and stuff. They ain't trying to spend all that money in down Bortlen. They trying to get him in and out. Hey, Mickey, you was just saying I'm taking the trial. You still taking the trial, or you taking the 16? In this situation, with the evidence that they have, I will take the 16 in this situation. Because he gave a freaking statement. That's still in. They played the statement, even at Melly trial. Like, it makes no sense. Like, on some real stuff, like I said, if you got an option to fight and poke holes in the story, that's one thing. But I asked y'all that said they had no evidence, how the hell you was going to explain to the jury why the world you got you with the victims when they was alive and when they deceased. Lamar said they ran out of money. Right, you already know. That's why they trying to plead that man out. Mind you, they ain't put off on the table until Melly trial got pushed back again. They never planned. Look, in my opinion, the plan was always for Melly to go first because they know the outcome of Melly is going to dictate Bortlen. Okay, the outcome of Melly was always going to dictate Bortlen. That's why even Bortlen team want to wait until Melly's situation. That Govan Hernandez trial got guilty. MF was taking shit to trial. That boy done. He taking it all the way. Hey, Hernandez Govan was a different situation. They ain't had Hernandez Govan on no freaking video with no bodies. For real, state has unlimited amounts of money. That's capped too, Black. Like, they don't have no unlimited amount of money. They, oh no, y'all be making my head hurt sometimes. But they don't have no unlimited amount of money. The free, they got bosses that got to answer the bosses that got to run for re-election. And how the hell they just gonna be telling they people with a no-go about all this wasteful money? It's a bigger picture to that. Like, nah, they ain't got no freaking unlimited money. The people that got money, oh, they definitely gonna have, the next time they have that charity fundraiser for $5,000, $10,000 a plate, oh, they gonna talk about that. Like, brother, you want to stay in your job, you better figure this shit out. Ain't got no unlimited money to keep going to trial about the same damn case. Come on. The plea will help them give the botched Melly trial some validation. Shit, they ain't got to. I mean, not really. Because he don't admit to nothing. Like, what is y'all missing? No contest. You're not admitting to nothing. If you drop the murder charges, how the hell can you say it had some, like, he's not even pleading out the murder. What is y'all talking about? I'll take the plea for 16 Alex, okay? Like, it's crazy. You can't even give the police your ID without the internet saying you snitch. Child, listen. Child, listen. Y'all know this internet is undefeated, okay? If he don't take the 16, it's over for him for sure. With the evidence they got as of right now, y'all hit the like button. It's for sure. Unless they start taking some of that stuff out, he done. Cook. And I ain't too quick to say that he cooked. And only get asparagus and shrimp on a $5,000 plate. Okay. For real. And Bortlen take that to trial. He won't win, I believe. And I can see his ass trying to take it to trial, though. I can see it. Man, 16 years is a long time. For sure, it is a long time. Like I said, it's just the evidence against him. Like I said, if I was on the jury, I would convict him. So, like, as it stands, like, for sure. Mickey Street Ninjas think he did it. They can. Bortlen ain't thinking about circumstances. He thinking about the fame and street credit of not snitching and beating trial. Stupid YN. Well, if he thinking, or whatever, if you think about anything street related while you fighting a case, your ass crazy as hell. Oh, Lord, it's itching so bad, y'all. I definitely got him going all the way. Yeah, I believe he probably will, though. Somebody probably gonna tell him some dumbass scenario. Some of them, it might be people close to him that feel like how some of y'all, they ain't got no evidence. They offer you 16, they ain't got no evidence. And ain't gonna send your ass no money for 16 years when you're doing them life sentences, How much time credit does he have already? I mean, they ain't really breaking down, but according to the chat earlier, I think it was like 3 years or something. He lose trial 15 years, he gonna be really upset. And then remember, the judge put on record, like, I'm telling you this now, so you can't come back and say that you didn't know you could do this. So that's already, everybody talking, oh, appeal. Like, the fuck don't put all your money on appeal, okay? Appeal is normally, if all else fails, you're supposed to give it your best shot the first go around. Don't just do dumb stuff because you talking about appeal. You have to have a reason. And you can't even say, oh, I had ineffective counsel when the judge said and told you on record, hey, I'm telling you this now, so you can't come back later and say your attorney didn't know or you didn't know because your attorney didn't explain it. I explained it to you. You know? Mika, good morning. Bay said, what do they got against Melly? A song. This ain't even about Melly today. We talking about Bortlen. The judge scared him and said if he don't take the deal, he will have 2 trials. Well, that shouldn't scare him, to be honest. That shouldn't scare him. Because he knew he had 2 damn cases. So he should already have known that. The fact he took the bodies to the hospital, thought he wasn't going to be charged or something was crazy to me. Okay. Queso banking on an appeal. Queso ass ain't getting out. Queso ain't, unless somehow they come up with a way to prove but a lie that Queso wasn't in the car. Queso ass gonna be right where he is. But he doing what he's supposed to do, trying to fight what he got going on. But he definitely okay ain't getting out. I'm gonna laugh if he rejects the plea and Melly snitches to get a sweet plea. Melly can't snitch. Who is Melly snitching on? That they want. They want Melly. They done told the citizens of Miramar or whatever it's called, Broward County, that Melly did this. Who they gonna want more than Melly? The family want Melly. Hell, one of the victims' daddy every week posts a video about Melly. They not about to let Melly go. He can't tell on nobody. Nobody. No, it's definitely over for sure. My first cousin was offered 15 years for 2 bodies and gang charge. They offered him 15 years. He was 17. He took it to trial 81 years. 20 years later, he filed for a new trial. And that's how the freak it's going to be. On some real stuff. That's what it's going to be. Hold on. Let me make sure I ain't got the thing. All right. But yeah, that's exactly what it's going to be. Melly can't snitch on no one but himself. Okay, and that man have been in all these years. How many years? Has 6 years? 7 years? That man ain't about to say nothing. He ain't never talked to the police this long. And that's what's going to be able to be used in his favor. Because he never made no statement. Bortlen did. Even though it was part of the play or whatever, they still using that statement against him. They can prove he lied. That's not going to sit well with a jury. It's one thing with Melly, like I said, Melly ain't never said nothing. Bortlen did. And as long as that statement is still in there. Oh, my head is so bad. Let's see. All the way, gotta give them 5 life sentences and about 70 hit. No, bro. Better especially testify. Telling you. Hold on, give me a second, y'all. I'm gonna blow my nose. All right, I'm back. Hopefully, whatever hearing they got going on right now ain't gonna take all day, so they can go ahead and start. Where we at? You think he gonna cook YNW Melly? Who? I don't think they even need Bortlen for Melly. That's me personally. They got his statement. They introduced it at the first trial, so I don't think they actually need Bortlen for Melly. That's my opinion. Ugh. This boho here be tangled like a mug. Okay, where we at? I would take the plea for the simple fact that crazy ass nigga tried to put the whole thing on that young man. When? When did he do that? telling me something I ain't never. I would definitely have did a video like that. Jesus, when he put it on him. If he takes the plea, if he takes the deal, he cook him. No, I don't think so. If Bortlen decides to take the plea, he should go on and testify and get a better deal. He's never gonna do that. He would have been did it. I'm pretty sure they been trying to get him to roll on him. Assuming he did it. Again, assuming he did it. We know somebody did it. Could have been him, could have been somebody else. I don't know. Because the first trial, they didn't prove it to me. Black license, I'm telling on the whole city. I know that shit, right? Look, somebody need to tell what the hell that man did with my cousin. That's what I care about. Somebody tell me that. So y'all know my cousin is still missing. Little segue real quick. Day 7. Any information, there is a reward being offered. Contact Crime Stoppers, City of Columbia Police Department, me, any of the family. Her daughters are active on social media, TikTok, all that. So definitely reach out. Oh my gosh, this one hurts so bad. I heard Melly lawyer did at least that what AK-47 said yesterday. Man, I love AK-47, y'all, and I hate when y'all bring AK-47 up because I don't want it to be like no shot, just like with anybody else. But at the end of the day, everybody put pieces together their own way. AK thought process is from a street perspective, so I'm not sure what he said, how he said it, or why he said it, but it still doesn't change the fact of my perception. And I never heard during the trial, from a legal standpoint, that it was ever attempted to be put on Bortlen. I could be wrong. I didn't hear that though, and I watched it every day, so I didn't hear that. So again, this is just my perspective. Don't know what AK said because I haven't watched whatever you're referring to. I appreciate it. Picture this and that. Chelsea said he's assuming that. I don't know. You like Chelsea, you came in and said something about what he said. I don't know what he said. I'm going off of my knowledge of what I watched during the first trial, and that wouldn't have been my perception of what was said. So I don't know. This is one reason why I don't like y'all mentioning in other creators' names, because again, everybody got their own way of breaking things down or whatever, and half the time I don't even watch whatever y'all talking about. And the only reason I'm mentioning it about AK is because that's my dog. But that's really why I don't like y'all doing that. Because like you asking me if he's assuming, I'm telling you I don't even know what he said. I didn't watch it. If you didn't bring it up, I wouldn't even brought him up, AJ said, what would you do? I would fight it. My boy can't go down by himself, even though I know what happened. Hey, if me taking a deal don't include him, the fuck should I be worrying about him for? Like, on some real stuff. Like, these cases be about you at the end of the day. Like, it be about you. So, I mean, of course, if me and my homegirl, we in on some shit together, then we know, whatever. But at the end of the day, if my situation don't have nothing to do with your situation, then you got to think about you. I got to think about me. As long as we don't include each other, we good. Y'all chill out on AK-47. Like I said, at the end of the day, it's all over me, AK-47. We don't have no problem, okay? I'm just saying, this is what I'm saying. Y'all got to stop coming over here saying what somebody done said and asking me my opinion on something and trying to make it seem like I done listened to what they said. Like, I don't know what he said. I want, off my perspective of what I watched when that trial was going on. That's it. Real talk, they want Bort to talk. He already started. Oh shit, where we at? That's why he threw Bort the deal. Bort probably didn't know it was going down like that. He took them to the ER. It don't matter. He knows something. So, I mean, at the end of the day, he still knows something, you know. Yes, they're in the same jail. Mickey, he be blocking MFers when they be supporting his bozo ass. I block a lot of people too. I block people all day. I mean, it's not. I don't be on live like he be on live. Hell, I block people every day. I mean, it's channel. He can block people. That's it. Good morning, Haitian K. But I damn sure block people. Okay, quick. Are some people against taking pleas like they think it makes them less masculine or ego buzz, so they take it to trial? It's more so, I think it's more so just the urban narrative with pleas or whatever. But at the end of the day, good morning, AJ. But at the end of the day, is you just got to understand what you're getting yourself into. You got to understand what you're signing. Half the people that be speaking on what a plea is and all that don't even be knowing what the hell be going on. For real. That's it. And no, you ain't got to be no career criminal to understand it. Because I hate when people say that. That's why I done start popping shit back at y'all. Because I used to hate that one. Oh, you ain't never did no time. You don't know nothing about this. But I done worked on hundreds of cases of niggas just like you doing time. So the hell, that got me with anybody. You know? This street stuff. No, this is court shit. The fuck is we talking about? That joint used to get on my nerves so bad. But I'm be honest, them trolls don't be out no more like they used to since I've been cussing their ass out. Because when I finally start saying that, it was crickets. Now these is my good sisters. I done dulled them out by cutting his damn hair. Oh well. These was my arts and crafts sisters. I hope I ain't cut my hair. That's the only dilemma about having long hair and then putting like weave braids or whatever in your hair. It's hard to know where the hell your hair is. I'm almost done. Almost done. And then I'm just going to let my hair breathe today. Because I get my blowout in the morning. Because I done had braids in my hair since June. I'm about to look at the comments in a minute, y'all. Trying to finish cutting these pieces here. This shit done dole my scissors out. I'm almost done. Alright, here we go. What was that? Andre said, as a retired street end, it's just law, no pleas, no talking. But who ever did that though? Like, and this is just a question. Anybody, like, who on your street ever did that? Has anybody ever on your street never said nothing, did no talking, took no plea before? Whether, again, ain't got me no corroboration, but that's the most dumbest shit ever. Who on your block ever not said nothing, not took no plea, not did nothing? Who? Anybody in the chat? Put a 1 in the chat for those that have that philosophy. If you have somebody in your area, on your street, your block, your neighborhood that ever did that, put a 1. Put a 2 if you ain't never even seen that. Because I have yet to see that. Because I done seen cases with niggas taking pleas left and right. And again, it ain't technically the pleas that you telling on nobody, but definitely the scene don't take pleas and stuff. So if that's the rule of the streets, y'all need to change that, because that's not accurate. The nigga that probably came up with that probably done took a plea or some shit. Like, that's not, oh shit, I think I cut my hair on this one. So, yeah. Yeah, that's crazy. Good morning, me mom. Thank you, Marquise. But yeah, y'all. Stop talking about some what it's like. It's never been that. Never been that. On some real stuff. If he take a plea, that doesn't mean he have to testify, correct? Every day. They take pleas every day. That's I'm like, that's crazy. Okay. I don't know where you from, but that's crazy. So that should have never been in the rule book, because that's crazy. That is crazy. That do make sense though. I do agree with no pleas. That's some bullshit. In certain situations, that would be dumb shit. I'm gonna be honest. Cause sometimes people have to take pleas to stop the furtherance of an investigation when it's a bigger shit at play. Hell, how I look at it, hell, if you got a illegal business going on and somebody need to take a plea to get 5 years to stop 10 people getting from 20 years and ruin the business, then that one person should take that 5 years and get taken care of during 5 years. Like, that's just how I feel about it. When there's a bigger picture. And at the end of the day, most like real illegal businessmen, as I said, illegal businessmen, it's a bigger picture at play. Somebody got to take the L so the business can win. And that's just, you might just take a regular plea. You take the heat for the team. But I ain't talking about telling and all that shit, because that's when the business fall apart. I'm just talking about situations where one person taking a plea might save 5 other people. Like, it just, he's not gonna win on appeal either. Like, what would be his stance on appeal? And we talking about Bortlen, y'all. Like, what would be his stance on appeal? Unless a law change, like, what would be his stance on appeal? What would be his reason? Y'all, you don't automatically just get an appeal. You have to apply. And you got to have a reason based off the law to why you should get it. I feel what you're saying, Mickey. That makes perfect sense. Yeah. Like, again, even though it may be illegal, whatever they got going on, you got to remember it's still a business. That's why I ask y'all all the time when we talking about, like, you got to think of it as a business. If something, like I told y'all, as a business, as my Mickey True business, right? Pulling paperwork and not getting the money off YouTube, like, for real, to make up for it made no sense. So I stopped pulling paperwork for content because it didn't make sense for the business. However, doing it on the back end and every now and then, depending on what it is, makes sense for the business. I'm gonna do it. So you got to adjust to what works for the business. You know what I'm saying? 16 years and testifying is pretty crazy. I'll testify with like 5 years, but 16 to testify is crazy. They ain't said he had to testify. Nothing wrong with the plea if it's only affects just the person taking a plea and nobody else. I mean, I ain't gonna say that pleas can't affect other people, but the thing is, as long as you don't include other people, it's up to them to make sure that they're not painted as a person involved in the situation, is what I'm saying. See, like a lot of people with this Boston Richie situation with the feds and how everybody beat it. Because collectively, they probably ain't had no evidence as is. So nobody took no plea, no nothing. It makes sense. But sometimes there's more evidence on one person than another person. And to stop the bleeding, hey, that person may have to take a plea. You gotta sit down for appeal. It takes years too, right? Look at C-Day 600. That man say every year he getting out on appeal, and he done lost multiple appeals, but he still fight. Rondo number 9 lost most of the appeals, and what they done been in there over 10 years. So you can't just count on an appeal. Oh yeah. Why did they offer Bortlen a plea deal? Hell, to save money. Why take it to trial? You can go ahead and just get it done. Why you think the feds be so quick to offer y'all as a plea? Hell, it save money. Trials is expensive. It's expensive. Ooh, shit getting tangled. All right, hold on. Give me a second. Oh, shoot. Listen, that stuff, I don't know what that stuff is they braid your hair with. It be having my hair tangled. Hi, where we at? You say you missed the live yesterday. What exactly is offered? It's so lengthy. Hold on, because I think the judge got up for a break real quick. So let me pull it up. Mickey, you tapping into that Young Thug ish, or you staying away? I ain't messing with it. Cause like I got a lot going on in my personal life. I've been trying to, cover my cousin disappearance for content, still stay on top of my trial stuff, that Young Thug stuff. Cause at the end of the day, hey, niggas be bored in there. Okay, they just be talking. They be talking about whatever. They wanted to feel like they part of the outside world. So at the end of the day, it's like it is what it is. He talking shit. Most niggas in jail want to talk. They want to feel like they part of what's going on. So yeah, I ain't messing with it. Now, if I didn't have my personal stuff going on, I probably would have, because it's good content just for people talking. But other than that, nah, it's not something I'm about to do though. Cause like I said, right now it's just, it's not the time. I barely be in the mood to do this content. Who you think leaking his calls though, and why? I mean, because it's public. I don't know why people be thinking them things private. I'm pretty sure it's somebody on the back end that's selling them to somebody for sure. That's one thing, because there's a lot of people that y'all may not even know who they are, but they be on the back end doing things. Because I know a few that do paperwork. They're not in the front type of content creator, but because sometimes if it's something, hey, they be like, yo, Mickey, I got this. Hell, Zebby is one of mine too, even though he is a content creator and he be blogging, he be in the background a lot. He don't really come to the forefront. So if they got people that do paperwork like that, hell, I'm pretty sure they got people that do FOIAs. The Chicago sector is full of them. So, see, me personally, if I get it, I'm gonna put it out myself. But everybody don't have, want that. So, hell, I talk about people on the regular phone. Hell, not even a jail phone. So shoot, half the time, if a lot of our group messages or text threads, phone, we all talk about people, especially celebrities. I talk about them on here, so I'll talk about them quick. Don't know these people and talk about them. So that's why I say it really wasn't. Again, it wasn't that deep for me with the jail phone calls. As a content creator, if I was doing regular content, I probably would have did it because it definitely had people, going. But other than that, like as far as what I personally feel, like we all be talking about people. All you have to do is figure out what company the jail uses, and the records are easily accessible. But at the end of the day, listen, at the end of the day, ain't nothing but a few Securities. What is it? Global Tell Me is not too many, not too many places. But yeah. And then he got to remember, he's a fucking celebrity. Like, if it's a way to they gonna get your stuff. That. He should have known that. He knew that. He should have had them high-powered lawyers put in a motion to not. I can't even think what would the motion be called, but try to get that shit locked down. But come on, he knew that shit was coming out. They was leaking out when you was locked up. You knew it was coming out. But hey, no calls be 15 minutes. And if you out for an hour, you gonna be running your mouth, talking about everything. Everything. Cause you wanna feel like you part of the real world. That's it. Yeah, well, for one, we're waiting on them to even start. They had another hearing going on, so we're waiting. And y'all know I try not to leave y'all in silence. So since I was taking my hair out, I'm just sitting here shooting the shit with y'all until they start. But I do have to leave in 45 minutes. So hopefully they start within 45 minutes. Y'all, no cuss words in the chat though. Y'all, if y'all need to use cuss words, y'all got to spell it a different way. I do not want my live not to be monetized because y'all cussing in the chat. So please change the words. Change it around if you must use it. Is this the last one? Please be the last one. Oh, please be the last one. No, I'm not ending the live in 45 minutes. I have to go though. My live will still be up. Oh, I have to go. Mickey, you think baby and them going to stick beside Stud through snitch allegation? Stick beside them for what? Like on Sarissa for what? Like what you mean stick beside them? To do what? When will you be back? I don't know. Probably at the end of the live. I have to go out and look for my cousin who's been missing for 7 days. So y'all know I leave every day at 11 o'clock or near 11 o'clock. So I may be back on, I may not, I don't know. But y'all know how I do it if I am gone and can't close it out. But I think I may be able to close it out because I can do it on my phone. But if I don't, y'all know I always chop it down and make a video for those that's not able to watch the full live. Thank you, Andre. Your cousin is missing. How old are they? 56 years old. Y'all. So hold on. Since we got a few minutes, let me play the news clip. Cause definitely wanna give me a second. Y'all know my videos be so long. I just want to play a quick one real quick. So hold on.
For the public's health and locating a missing woman. 56-year-old Angela Fuller was last seen nearly 1 week ago. And just a few hours ago, her family and friends, they rallied the community for a search effort that is continuing. News 19's Shannon Taylor is tracking the efforts to get her home.
Very loving lady, very characteristic lady, fun, genuine. Don't take no mess.
But today made 5 days she's been missing. No calls, no contact, nothing. That's nothing like her.
Family, friends, and concerned members of the Columbia community gathered in the parking lot of the old Walmart on Bush River Road Wednesday, hoping their footsteps would lead to answers in the search for 56-year-old Angela Fuller.
We are setting a search warrant. I don't feel like comfortable just sitting at home knowing my mom is out here needing help or anything.
Angela's daughter, Monica Fuller, who didn't want to be on camera, tells us this is now the second event hosted in hopes of bringing her mother back.
And we're going to go look. We're going to go search. We always come together. It's only us, her husband passed, which is my father. So that's the only parent we have. So just sitting at home is not going to make me feel any better. Just out looking day, night, go to sleep at night, start over, reset, look for her till she's found.
According to Columbia Police, Fuller was last seen on Friday, August 29th, near the 3000 block of North Beltline Boulevard, close to the intersection with Covenant Road, wearing a white t-shirt, gray basketball.
All right, the hearing started.
To have Ms. Collins, Mr. Griffiths present for the state. Mr. Haddad, Mr. Nascimento present for Mr. Henry, who likewise is present. So I heard the evidence yesterday, and the defense's pending motion to suppress statements from Cortlen Henry. State, am I still correct? There's no other additional evidence, witnesses, or testimony you would like to present as to that motion? And defense, there is no additional evidence, witnesses, or testimony you would like to present as to that motion.
We would like to present the testimony of defendant Mr. Henry
Oh.
for the limited purpose of what happened.
Okay, no problem. Mike, can you hear?
That as loud as it's gonna go.
Yeah, Mr. Henry, just, you can stay right there with the lawyers, just speak loudly, okay, so we won't hear the answer.
So my volume is maxed out.
Swear to tell the truth, whole truth, nothing but the truth? Yes, sir. Okay, you put your hand down. Please state your full name and spell your full name.
My name is Cortlen Henry, C-O-R-T-L-E-N.
Okay, sir, you may inquire.
Thank you, Judge. Mr. Henry, we just want to talk about what happened in the hospital on October 26, 2018. Do you recall driving to the hospital? You got to speak up and answer yes or no.
Yes.
Okay. And then at some point, when you were brought to the hospital, were you placed into a room? When you were placed in that room, approximately how many officers were present?
5 or 6.
Minimum?
5 or 6.
And approximately, if you can remember, how long were you in the hospital prior to the 2 detectives arriving? You were there for a little bit before they got there.
Oh, wait, what did you say?
The detectives.
The text on top of it?
And describe to me the room that you were in. Was it were you there by yourself with other people in the room?
It was like a private hospital room. We probably maybe like 4 different officers in the room. They had some outside of the room.
While you were in that hospital room, at any time were you placed in handcuffs?
Yes.
Do you recall who placed you in handcuffs?
One of the officers.
You're saying one of the officers. Are you differentiating officer versus detective?
Yes. One of the officers that were standing with me.
Okay. And while you were in that room prior to giving your statement, was there always an officer in the room?
Yes.
And at any time were there any officers in the doorway?
Yes.
What were they doing?
They were just standing there.
At any time prior to giving your statement, did you feel as though you had the ability to get up and leave?
No.
What do you think, in your mind, what was your impression that would have happened to you had you tried to leave?
They're gonna let you go.
Prior to you giving your statement to the officer, the detectives, at some point were the handcuffs taken off?
Yeah.
Why?
They want me to go and take, they want me to go to
The urine set? Okay. Was there a bathroom inside the hospital room?
No, they walked me.
Okay, you said they walked you up on the officer?
One of the officers, one of the deputies that was standing guard in the wing, they walked me out, they walked me into a separate bathroom restroom outside.
Okay. And at that entire time while you were providing a urine sample, was there always an officer with you?
Yes.
And after you gave the urine sample, did you get brought back to the room? And then at some point, there are 2 detectives that come, right?
Yes.
At any time during your interaction with those detectives, did they tell you were free to leave? So then the first question.
Okay, cross-examination, go ahead.
Mr. Henry, you were taken into the hospital room for medical treatment, correct?
Yes.
You're aware that there is no urine sample in evidence, or collected in evidence.
As loud as you can.
No, I'm not aware.
You stated you were handcuffed. How long were you handcuffed for?
Most of the time I'm there. In the room.
So you were handcuffed for over 2 hours in that room, which you're testifying to.
Yes, until I can pay.
Same voice.
until he said I can leave. So I leave.
Did you ever try to leave?
No.
Did you ever ask to leave? Did you ever discuss with the nurses that you wanted to leave? I'm going to show you what they marked as states for evidence. Do you recognize this picture? Who's that a picture of? And where are you? Are you wearing handcuffs in this picture? This time I'm going to stage B and evidence in states 2.
Any objection?
No objection.
Without objection, states B for identification is now going to be an evidence that states Exhibit 2 only for the purposes of this hearing.
Mr. Henry, you agreed to ride with Detective Toyo after the crime scene? Where you said the crime occurred? Did you ride with Detective Toyota, who testified yesterday, out where you said the crime scene occurred?
Yes.
And you were seated in the front seat with him?
Which I'm going to check. It's outside the scope.
Well, it is outside the scope, but over the defense's objection. Go ahead, sir. You can answer the question.
You did not ride with Detective Toyota?
I didn't ride the front seat.
You were in the back seat? Okay. And at the end of your interviews with the detectives, they offered you a ride home, correct? They did not offer you a ride home? And they did not give you, law enforcement did not give you a ride home?
No further questions.
All right, based on that, any redirect?
So just briefly on the photo.
Yeah, just real quick.
Mr. Henry, this photo that you were showing of you in the hospital, do you recall pictures being taken of you? Do you recall the officers taking photos of you? Was this taken before or after the handcuffs were taken?
Objection, Your Honor, said it doesn't call.
Hold on. Over the state's objection. Go ahead, sir. What did you answer that question?
You said you recall some photos being taken. Those photos that you recall being taken, were they taken before or after the handcuffs were taken? After. No further questions.
Based on that, any recross?
No.
Mr. Henry, I got a couple questions for you. You didn't get arrested that day, correct?
No, sir.
How'd you get home?
Family friend came to pick me up.
Someone came and picked you up at the hospital?
Yes, sir.
And do you know what the time period was between that day and when you actually did get arrested?
That was October 26th. I was arrested January 28th.
All right, state, based on my questions, do you have any additional questions?
No.
Defense, based on my questions, do you have any additional questions?
No, Your
Okay.
Honor.
Defense, any additional evidence, witnesses, or testimony regarding the motion to suppress?
No, sir.
Okay, so it's just argument. So, defense, it's your motion, so when you're ready, take your time. Your argument in support of your motion to suppress, and I assume you want to suppress, well, I heard, which I think is contained on State's Exhibit 1. For this hearing, there's two statements. There's a longer statement that's about 40-something minutes, and then there's a very short one, which is like 2.5 minutes. You want to suppress everything? Okay, go ahead, sir.
He was not Mirandized, as we know. I think the state is stipulated for that. But what the issue is obviously, he was not at the police station. There's an issue of whether he was in a situation where he should have been Mirandized. Whether the interrogation, as it were, constitutes an interrogation, whether or not it's custodial. Now, the defendant, the police had a shooting. We heard the testimony that a car arrived at the hospital with two bodies. Mr. Henry was driving the car. Two bodies were taken into the hospital. Mr. Henry was taken to the hospital. And he told the nurse or somebody that was there that there was a drive-by shooting. He explained to them where it happened. We know from what the detective testified, other police people, personnel that were present and talked to Mr. Henry, then went out and walked the scene, canvassed the scene, looking for evidence of a drive-by shooting. They were unable to find evidence of the drive-by shooting, and the detectives came and talked to Mr. Henry. You've heard the tape, and I just want to quote from this transcript of it. The defendant is confronted with, as he said, the police corroborated there were at least 5 or 6 cops in the room, everybody around him. He was in a situation where he's, I'm going to call it a custodial situation when we get to that point. But at any rate, the statement was, the defendant is confronted with Bertrand and Moretti. Hey, Henry. Hey, man, how you doing? What's up, man? How you guys doing? Hey, my name's Detective Bertrand, and this is Detective Mark Moretti. We're here to talk to you about what happened, okay? Listen, you need to be straight up with us and tell us what happened here. My understanding, you told he's off to something, but the evidence doesn't show that happened right here. That's confronting the defendant with something that's confined. Moretti said he committed a crime there. He was lying to the police. So we know that they're confronting him with evidence of falsehood. Should he have been Mirandized, because the rest of the statement is what they're using to formulate the rest of the case. And I would submit to the court that the police had a duty to Mirandize him under that situation. They formulated, they have a crime, there's no question a crime committed, occurred. They called it a crime scene. The scene at the hospital was taped off. It was an active crime scene. Half the Miramar Police Department were there. 5 or 6 people were guarding him. He's in a situation where any person would feel they were not free to leave. He's in a hospital where people, he said there were 4 in the room with him. The detectives corroborated there were a bunch of policemen with around him. Was there a duty to Mirandize him? I submit to the court that in this situation, the defendant was, well, quoting from Hunter, Miranda warnings are required when an individual is undergoing custodial interrogation. As this court, this is the Supreme Court, as this court has explained, a person is in custody if a reasonable person placed in the same situation to his or her freedom of action was curtailed to a degree associated with the actual arrest. The proper inquiry is not the unarticulated plan of the police, but how a reasonable person in the suspect's position would have perceived the situation. Would a reasonable person in the situation of Mr. Henry have felt like he was not free to leave? Would he have felt like he was under arrest? The answer is obviously yes. He's there, some crime occurred. He is in a situation where the police are telling him they don't believe what he said happened. They made it clear that they think he's lying to the police. How would a reasonable person perceive the situation? You're in a hospital bed, you have policemen all around you, you're being accused of lying to the police. Would a person perceive the situation as one where they're free to leave? I submit to the court on the totality of circumstances, they would not. I concede the cases state that a hospital room is not necessarily the equivalent of a police station, but it's not the place where the inquiry occurred. It's how the inquiry occurred and what the situation is, how the suspect perceives it. Any reasonable person, it's a reasonable man's man, as to whether a person would reasonably believe they were in a situation.
I'm sorry. I apologize. Just pause 1 second. This is Martin.
I didn't even hear what they had to pause for. Because he like stopped them in the middle of him making his argument. So I don't know what just happened. But they was doing something.
All right, Mr. Henry, I apologize. That was regarding a medical issue of women taking the call. I apologize.
I can go to
Oh, he had to take a
Russell's
phone call.
court, which they relied on it so heavily in its motion because it was a hospital situation. The court stated, quite correctly, police are not required to give Miranda every potential suspect. Miranda warnings only apply in custody investigations, court cases. Then it goes on to say the reasons for Miranda warnings at this stage because interrogation, certain custodial circumstances inherently coercive. Statements made under these circumstances are inadmissible unless the suspect is specifically warned of Miranda rights until he decides to waive those rights. And then it says for Miranda purposes, custodial question interrogation means questions initiated by law enforcement officer after a person has been taken into custody or importantly otherwise deprived of his freedom of action anyway. The determination of whether a person is in custody for purposes of Miranda is how a reasonable person in the suspect's situation would perceive the circumstances, relying on Yarborough in those cases. A person is in custody, quoting from Hunter, a person in custody if a reasonable person in the same position would believe that his or her action, freedom of action, was curtailed to a degree associated with actual arrest. And I quoted that before. And that's the situation we have here. The defendant is in a room. He is confronted by the police that they don't believe what he's telling them. That he's lying to them and they have to come clean. And then he's not Mirandized. He's surrounded by a bunch of police. He goes to the bathroom. He has police taking him to the bathroom. He's in a room where the police agree he's surrounded by police. They said there's a bunch of police, but 4 or 5 sound reasonable from what the defendant is saying. They're consistent with what already testified to. It's how many police are here. He's in a room. It's a confined place. He's got policemen around him, and he's confronted with evidence that he's lied to the police. Should he have been Mirandized? Absolutely. It's a statement that is going to be used against him in the obstruction case or accessory case. He should have been Mirandized. I think under the circumstances testified to as to how this occurred, the defendant had a Miranda warning under all the cases given. Thank you.
State, yes, Judge. Starting with Mr. Henry's testimony, he's clearly not being forthright with the court. As Detective Cox or Officer Cox testified to, when he first got to the scene, Mr. Henry was sitting outside on a stone bench when he went over and asked him what was going on. When he is questioned in the room by the detectives, they testified that he is not handcuffed. In the photograph, he is not handcuffed. Detective Toyota takes him on a ride. If he was really a security risk, if he was really somebody they thought was a suspect, Detective Toyota never would have taken him on that ride, and they never would have offered him a ride home. That offer for the ride home is at the end of that reporting, where they say, like, we're going to make arrangements to take you home. He was not a suspect. As the officers all, excuse me, the officers all testified, They thought he was a victim. He was receiving medical treatment because, as the defendant stated, he was among the people being shot at. So when we look at whether something is custodial or not, it's the Ramirez test, as outlined in Ross, which is the manner in which the police summoned him for questioning. He was not summoned. He brought himself to the hospital. The hospital was a crime scene. There were officers there. Crime scene was there. They were processing the vehicle. They were processing the deceased. They were processing for evidence, potentially evidence physically located on Mr. Henry as a victim. The fact that the court heard the purpose, place, and manner of the questioning. This questioning was non-confrontational. He's not confronted with any evidence. They're not saying, you know, we found bullet casings, not saying we found GSR. The confrontation is, we don't think this happened where you said it happened. And if you look at the transcript, you read the transcript, you can see that. Because on page 9 of the transcript, they're like, look, here's a crude drawing. Did you guys get off the ramp here? Did you drive past the Chick-fil-A? They're trying to figure out where this happened. As I think 2 of the officers joked, we were trying to figure out if we even had jurisdiction over this case, depending upon where it actually occurred. There were not 5 or 6 officers in the room. That never happened. What the officers testified to is that there were officers around, you know, nearby, and there were, because this was a crime scene. There was an active shooter loose based upon what Mr. Henry told police, because he was a victim of a drive-by, which means somebody is driving around shooting up vehicles. So of course police are going to respond to that. But he's not confronted with any evidence of guilt, and even if he is, of course, considering that, as I cite to in, Pitts, which is very parallel to this case at the end of my first section for issue 1, is even if they are confronted with some evidence of criminal activity, that does not necessarily transform it into a custodial interrogation. He's not confronted with any evidence of him committing a crime. It's just, did this happen where you say it is? And when we look at the entire context of the conversation, the tone and manner, this is not an aggressive confrontation of him being a suspect. This is, tell us what happened. Where's the location? Who are the victims? What, did anybody have a beef with you? Are you posting on social media? They're trying to figure out what happened, what is going on, the basics of the investigation. And I believe all 3 witnesses testified, we believe he was a victim at the time of that. It's a reasonable person standard. The fact that he is having, that they're documenting his injuries, that's normal in nearly any crime. A victim of domestic violence is going to have their injuries photographed. A victim of sexual battery is going to be transported to the sexual assault treatment center for potential examination. And they have the right to refuse, which is what the officers testified to. Had he wanted to refuse, we would have abided by that. There's no evidence, pardon me, there's no evidence supporting that this was a custodial interrogation or ever transformed into a custodial interrogation. Miranda warnings were never required for this because, as the officers testified to, at the time that they were questioning him, they believed Mr. Henry to be a victim of this. That's all I got.
Thanks, I'll give you the last word. You guys want?
But if I may, I have to disagree with the statements. I do think that the beginning portions of the transcript were replete with instances of the detectives confronting Mr. Henry with what they believe evidence of him lying and not telling the true story of what happened here. We see it in the second question. First question is this Henry, but the second question is the evidence doesn't show that it happened there. You lied to us, you're not telling us the truth. If you go on to page 3, we see them confront him on the bottom. Here's the hard part. We're having a real hard time trying to understand is that we shut down the entire area. We had officers at the shoulder walking out. They didn't find as much as 1 shell casing. They go on, but they end with nothing to what you said adds up. You're lying, Mr. Henry. You're not telling us the truth. We think there's more to this. Later on, they go on, we should expect to find evidence here. And it's describing that to them. Right now, there's nothing, okay? I kind of think I know what happened because I got information that something else happened on the east side of the city. But it sounds similar to your thing, but you need to tell us. You need to be straight up with us, okay? Next question. You're doing your friends a disservice. So repeated examples of them telling him at the beginning of the statement, what you said to us is untrue. You are lying to us. We've done an investigation. The evidence that we have doesn't match what you're saying. We're confronting you now with the lack of evidence to support your story. So clearly, they're confronting him with evidence of his guilt or involvement in some way in either the accessory after or the murder itself. And as far as arranging for a ride to go home and being in a ride along with the officers, that matters not as to what the environment was when Mr. Henry gave his statement in that hospital. He has testified to this court, he did not feel he was free to leave. This court's going to evaluate that based on a reasonable person standard in his position. Whether or not he's in handcuffs when the statement occurs, again, matters not. There are officers, he was not free to leave the hospital room, he go to the restroom. I think it's easy to understand that had he stood and walked out of the hospital, they would have stopped him. He had been there for some time before the statement occurred. They were collecting evidence, because it was a crime scene, including evidence, GSR in his hands, taking his clothes, things of that nature. Things that a reasonable person would not understand to be happening to a victim of a crime, or someone who may be a suspect of a crime. And at the very end, Judge, whether the officers have testified they believe him to be a suspect or not matters not, as the case law tells us. In Stansbury versus California, 511 U.S. 318, the police officer's subjective view of the individual is not bearing on whether or not the person believed they were in custody, whether they express it or not to you. It's what happened to Mr. Henry that day, and was he reasonable in believing he was not free to leave? Was his physical motion or his right to decide what to do next curtailed by the action of the officers? And we would submit that it is clearly, if you evaluate it just in the vacuum of that room prior to the statement. Thank you.
Okay, listen, although normally the best practice would be for me to give you all a written order on there, I'm just going to work the bench because of the time constraints that we're under here, and we set the trial, commence the jury selection next Wednesday. So regarding the defendant's motion to suppress statements of Cortlen Henry, number one, I find witness Jordan Cox to be credible. I find witness Stephen Toyota to be credible. I find witness Mark Moretti to be credible. For the most part, I find witness Cortlen Henry to be credible, except maybe as this handcuff issue. I just don't know. There's no evidence in front of me to the contrary. So let me put a couple things on the record right up front. Number one, it's clearly interrogation. Okay, there's no issue about that. They're asking him questions like, did you fire a gun that day? Did you have a gun that day? All right, those are questions that are meant to elicit or could elicit an incriminating response. It's clearly interrogation. That's not an issue. Number two, certainly the best practice would be for homicide detectives to just advise the person of his rights. And were they to advise him of his rights, then we don't have to go through this 2-day procedure. And I'm not called upon to make this determination. But for whatever reason, law enforcement doesn't really seem interested in doing that on a lot of these cases. So I have to make this determination. So really, the whole ball game here is whether he's in custody. And I'm familiar with the case law that the state cited. I reviewed it again. I'm familiar with the case law the defense cited. I reviewed it again. The bottom line is, I don't think he is in custody. And I'll put the reasons why on the record. Let me also make this clear. If I had a photo in front of me, and I don't care where it was taken, if it was taken outside in the bay of the emergency room entrance, if it was taken inside the hospital, I mean, there's video cameras all over these hospitals. Maybe not the treatment rooms, but if I had any picture or any video of anything anywhere at any point in time Mr. Henry had handcuffs on, I'd probably feel differently about this, but I don't. I have nothing that supports that in front of me, number one. Number two, they did in fact let him go. Number three, I think this defense is trying to give law enforcement too much credit. This is just a few hours after a double homicide occurs. And they're trying to, I guess, infer some nefarious purpose on behalf of law enforcement, that they knew Mr. Henry was a suspect, that they knew Mr. Henry was going to be charged. This is the perjury trap that the defense relies on or mentions in their motion. I don't think they had any idea what had happened up to this point. It was just a few hours after a double homicide. They're just trying to figure out what's going on, to the point of putting Mr. Henry in a car and driving him to the scene that he says where this took place because they're trying to figure it out. So they had no idea what was going on. They certainly didn't have any idea that Mr. Henry was going to end up being a defendant in this case. That seems to be corroborated by the fact that he doesn't even get arrested until more than 3 months after the fact. If he had ever asked to leave, I would feel differently about this. If he had ever told any witness anywhere that he didn't want to talk to them anymore, I would feel differently about this. He did no such thing. Again, based on the totality of the circumstances, I'm supposed to determine this. I listened to the questioning. I agree with the state in this part. It wasn't what I would call an intensive or aggressive questioning by the detectives based on their tone of voice and based on what they're trying to find out. They actually kind of go out of their way several times to say, listen, we don't care if you had drugs. We don't care if you were committing another crime. We don't care about anything else. We're homicide detectives. We're trying to find out what went on in the homicide. As to the defense's argument that there is a large police presence at the hospital, I would suspect that if any person in this room drove up to a hospital right now with 2 dead bodies in their car, there would be a very large police presence that would respond almost immediately to that location. So that in and of itself doesn't really sway anything in my mind. I think any reasonable person would have to expect that you drive up to the entrance of an emergency room with 2 dead people in your car who were shot, that you're going to be confronted with a rather large law enforcement presence almost immediately. So again, based on the totality of the circumstances, where I do find that the best practice would have been to advise him of some Miranda rights, and where I do find that this was in fact interrogation, I do find, based on everything that I've put on the record, that Mr. Henry was not in custody. Therefore, respectfully, the defense motion to suppress both the statements is going to be denied. I'll enter a written order that reflects such. If and when we arrive at the part of trial where the state tries to introduce this, that would be over the defense objection, which I would consider to be preserved, renewed, and contemporaneously made. So I'll enter a written order as to that. Next, state, you filed a state unopposed motion for relief from trial order dated July 8th, 2024, and that was for the purposes of filing a motion in limine to exclude the testimony of potential witnesses Michelle Boutros and Christine Bradley. I think you all told me yesterday the defense has no objection to your unopposed motion for relief from the trial order to file the motion, number one. And number two, the motion in limine is otherwise moot because they don't intend on calling Michelle Boutros or Christine Bradley as witnesses. State, is that correct?
I believe that's correct.
Correct.
Is that correct? Okay.
The way it stands, I don't believe we would.
All right. So,
And should that happen, we can address it.
okay. Well, as far as the motion for relief, just to file your motion, that's granted, and I'll enter a written order as to that. Regarding the state's motion in limine, I'll defer on that, and I'll enter a written order. And if no one calls them as witnesses, it's not an issue. And if someone's going to call them as a witness or wants to, I'll address it and give you a ruling on that. And if that requires me to send the jury out and even take a proffer from either one of these witnesses, it doesn't seem like it's going to be too long in time, but I'll take a proffer from them if I need to outside of the presence of the jury before I make a ruling. Although I can tell you, I have no policies, but as a general rule, credibility of witnesses is always at issue. So if we're talking about the credibility of a witness in the case, a witness that one side or the other side needs the jury to believe to have the jury believe their version of the facts of the case, then I would probably be hard pressed to say that I would prevent any witness testimony in front of the jury in that regard. But I'll enter all 3 of those orders today. Ms. Wilcox, this one on top is granted, the reasons stated on the record, and then the motion limited underneath is deferred, the reasons stated on the record.
The motion hasn't actually been filed yet. We just have to file.
Oh,
the
you're going to
motion
file
for
it.
relief,
I'll
so
consider
I'll
it.
file it today, but we won't
Do they have a
send it
copy of it?
anything.
They already have a copy of it?
Yes, they already have a copy.
All right, so I'll consider the state's motion in limine based on my ruling granting the relief from the trial order filed today, which is September the 5th, and I will defer ruling on it based on what I already put on the record. State, is there anything else that you need me to do for you regarding Mr. Henry today?
Not today, Your Honor. Thank you.
Defense, is there anything else that you need me to do regarding Mr. Henry today?
Not today. Thank you.
So Mr. Henry's going to keep a couple dates. Number one, next Tuesday, September the 9th at 1:30 p.m. We'll call that a trial status. So the record is clear on this. If there's going to be some sort of resolution, it has to be Tuesday afternoon. I can't take it Wednesday morning because I'm going to have the jurors here. There's simply too much human resources involved with this. And if Mr. Henry's case does resolve, and again, to repeat what I said yesterday, it doesn't matter to me whether it does or it doesn't. I have a couple other murder trials that are in line with in custody defendants. And I will use those jurors.
Not bring him here at 5 in the morning.
Yeah, just sign it. We'll give you a blank order. Just fill it out that says I need him here Tuesday, September the 9th at 1:30 p.m. 1:30 p.m. Mr. Henry, Tuesday would be the last day you're dressed like that. If we go forward with the trial on Wednesday, I need you in your trial clothes, okay? Dress for trial on Wednesday. We're going to have jurors here Wednesday. And then he has, besides the September 9th date at 1:30, he keeps his trial dates for September the 10th at 9 o'clock.
I don't need an order for 1:30. They'll open it for lunchtime.
However you want to write it up.
Yeah, but it's 1:30, they usually bring on the afternoon bus.
Yeah,
They
that's
bring-
right.
Yeah.
They'll walk over.
Yeah.
I'll take care of it.
Yeah, just
Okay.
okay.
Thank you.
Okay, very good. I already sent you preliminary jury instructions. For the benefit, Mr. Haddad might be the only person I haven't done this with. Mr. Nascimento did it some years ago, but I bet he remembers. And Ms. Khan did it far more recently. But on Wednesday, the only thing I'm going to do is march in 5 panels of 50 at a time. I'm going to have the same trial schedule without the case information sitting in each chair. So they're going to be told that I need them from September the 10th through up to and potentially October the 10th, Friday, October the 10th. There's 2 court holidays in there, Tuesday, September the 23rd, and Thursday, October the 2nd. I'm going to talk to each of those jurors regarding their ability to serve only as to the statutory reasons that I can excuse them. Regarding the schedule only, the lawyers won't have to say anything on Wednesday, September the 10th. Once I get 60 people is the maximum that I can see in here for a jury panel. So if and when we arrive at 60 people that tell me that they can serve, they're going to be numbered 1 through 60. They're going to come back Thursday morning. When you all leave here Wednesday, you will have a copy of my questionnaire that they have filled out. It's going to be numbered 1 through 60 and a seating chart so you know where each of those jurors are going to sit. And then starting Thursday morning, we are only going to address those jurors by their numbers. I have lanyards numbered 1 through 60. Mr. Court Deputy is going to pass them out every morning. He's going to collect every afternoon when we're done with the jury selection process. So we're not going to refer to anyone's name on the record. State, you'll know the names because you'll have the list. Defense, you'll know the names because you'll have the list. And I know the names. But again, pursuant to the pretrial orders that I've already entered, everyone's continued to be ordered. We're not going to disclose those names to anyone else. If any of the jurors' names are otherwise released to the public in any way, shape, or form, because I've already ordered the clerk not to do that as well, I am going to conduct an investigation to determine where the names are released from. And if I find out that someone has violated any of those pretrial orders that I entered, I will conduct an indirect criminal contempt proceeding immediately. So I would highly hope that everyone will comply with those orders. We're only going to refer to the jurors by number starting Thursday morning. I think that's it. State, anything else you need me to address before we recess until Tuesday at 1:30?
No, you aren't.
Defense, anything else that you need me to address until Tuesday at 1:30?
No, sir.
Okay, so I'm going to see Mr. Henry next Tuesday, September the 9th at 1:30 p.m. Division, Ms. Wilcox, that concludes Division FT for today. Division FT is going to be in recess until Tuesday, September the 9th at 8:45 a.m. I hope y'all have a good rest of your morning. All right. Just a court report. That is it.
All right, that's perfect timing because I just was about to have to get up out of here. All right, so what does, hold on. All right, y'all. So what does that mean? So motion to suppress his hospital statement, that's the only statement that Bortlen did, was denied. However, if at some point in the trial certain parts want to be brought in or whatever, they may be able to object to it because it's already been put on a record over their objection, but it was denied. They agreed, prosecution motion to exclude Bradley and the other DA has been granted. However, again, at the time, if they do decide to call them as a witness, they may have a conversation during trial. Bortlen has not yet decided to take the plea out. Not yet. He has until Tuesday, September 9th at 1:30 p.m. At that point, if he takes it, he takes it. We'll find out then. If he doesn't, then guess what? We'll be here on Wednesday for trial. However, it is jury selection. Wednesday, September 10th is jury selection. Normally, they don't stream that. If they do, we'll be here. If they don't, when the actual trial begins, we will be here. They seem like they are counting on it to extend into October. So if that's the case, we'll be here for a while. Y'all know starting the 22nd, I will be going back to evening content. So I won't be able to finish out the trial during the day. However, y'all know how we did with the YNW Melly case first time. I come in on the end. In the evening, we break it down. Even if y'all be watch it during the day, a lot of y'all will still pull up at night, okay? And that's pretty much where we stand. Y'all know my opinion is he definitely should take the plea, especially with that statement still in there, but we'll see on Tuesday. You doing Dirt case, I'll do content on Dirt case, but I won't be able to go out for Dirt case. Due to professional obligations, I won't be able to go. So yeah. That's where we're at, y'all. I got to get up out of here. I actually got like 20 minutes to head where I need to go. I appreciate y'all for pulling up. We've been live for about 2 hours. I'll chop it down in parts because we had to spend a lot of time just doing sidebar conversations and all that. So we'll do that. Did Bortlen ask for a bond? They did have a motion on record. They either it's just been denied or they didn't actually argue it in court. But yeah, let me get up out of here. I appreciate y'all. Y'all know, as always, y'all make sure y'all share. Like, run up the comments, and I'll keep y'all posted. But I'm out. Hold on, wait, before I go, y'all make sure y'all tap in with me to book your slot. A lot of y'all be hitting me up on Instagram and the email wanting to just talk about content, whether you're an up-and-coming content creator or somebody just got questions about cases or whatever. Book your consultation with me now. The information is on the screen. Hey, make sure you get your slot, because my slots be filling up fast. Mickey talks the truth.
Okay. I got truth on my mind. I got truth on my mind. I got truth on my mind. Truth on my mind.
Hey, listen, you are now rocking with Mickey Truth. She live up to her name, not the fame. So make sure y'all subscribe to her channel and stay updated on what's real. Bye.
Good reporting ass Mickey.
We love you, Mickey.